Good afternoon, everyone. Welcome to you all on this webinar organized by the Insolvency and Valuation Standards Board of ICI on the topic the Insolvency and Bankruptcy Code Amendment Bill 2025 Implications, Insights, and Impact. We are being joined by an eminent panel to speak on this topic, and few of them are also part of the lawmaking while this was being drafted. With this, I would like to welcome our chairman of the Insolvency and Valuation Standard Board, C.A. Gyanchand Mishra, sir.
Thank you.
Vice Chairman, C.A. Rajesh Sharma, sir. Then I would also like to welcome Sri Jitesh John, Executive Director, Insolvency and Bankruptcy Board of India. Then C.A. Jayesh Sangrajka, sir, who is an insolvency professional. C.A. Ashish Hocharya, sir, who is also an insolvency professional. We are also being joined by Mr. Suharsh Sinha, who is a lawyer and on behalf of AZB. We will also be joined by our Honorable President of ICICA, Charanjot Singh Nanda, sir, in due time. With this, I would request C.A. Gyanchand Mishra, sir, to give his welcome address. Welcome to you, sir.
So, thank you so much, Sarika Madam. Very distinguished Executive Director of IBBI, Jitesh John ji. Two very distinguished insolvency professionals, Ashish Chocharia ji and Jayesh Sangrajka ji. Advocate in today's panel, Suharsh ji. In absentia to the President of the Institute of Chartered Accountants of India, who shall be joining very soon to us, CA Charanjot Singh Nanda sir. And of course, Vice Chairman is also joining us very shortly. And all respected participants, CA Sarika Singhal ji, Secretary of the Committee, and all office staff, good afternoon to one and all. Indeed, it's a great privilege again to welcome all the participants in this today's very important webinar being hosted by the board, that is the IBC Amendment Bill 2025, Implications, Insights, and Impact. Friends, if we see, needless to say that IBC has been one of the very impactful law in recent years in the country. It has given complete reform towards the restructuring and financial arena to the country at large. If we see, so many things have happened in last 7 years. The expectations of various stakeholders were very high. Some issues which were being undertaken by the courts and of course procedural lapses. So I think that this was the high time when Honorable Parliament has thought about it to come up with IBC 2.0. And this bill is not only just another steps towards the reforms of the previous act of the code, but I will say this is certainly a foresight towards the Viksit Bharat in coming time, what the government is expecting. Friends, so many things which we were expecting, like group insolvency, and of course, related to the international insolvency, cross-border insolvency. So all those provisions which we were eyeing for last few years have been duly incorporated in the new bill. If we see certain voluntary powers being given to the authorities, that have been also checked in, and I think that might be beneficial to the stakeholders at large. The insolvency professionals, being one of the very key stakeholder to the entire process of IBC, have been given some better powers and rights along with the duties they have been assigned by the code. So if we see, we are heading towards the newer version of IBC, and the lawmakers have very thoughtfully written and analyzed the impact of the law. And today we have gathered here to discuss, deliberate, and find out the impact what we are going to see under new bill. We understand that the bill have been referred to the select committee, and we are expecting that with some of the changes, we can see it on floor in coming time. As the country is progressing, financial structure of the country is growing very fast, probably the highest growth country as of now in the world. So the need of IBC will keep its legs very strong. And we as various stakeholders need to be updated and upskilled so that we can deliberate and we can deliver to the best possible as expected by the government and various stakeholders of this ecosystem. I will not take much time. I once again welcome all the respected stakeholders who are present here. I mean, the panelists, and of course, we have Jitesh ji, who has been instrumental in writing the code, writing the bill, so we can think to have much more from his side. And three very learned panelists are here, Ashish ji, Jayesh ji, Suhars ji, who shall be taking the overall ecosystem to understand, deliver, and go ahead. I can see that CGS Nanda sir, Honorable President of the Institute, is joining us. So it would be a great help for us that we listen his views also with regard to the bill, and thereafter the panel discussion and of course the special address of Jitesh ji shall start. I welcome CA Charanjot Singh Nanda sir, Honorable President of the Institute, in this webinar.
Sir, he will start at 2:15. In the meantime,
Okay.
he has joined. So,
Sir, President sir will join, Gyan sir, President sir will join in another 4-5 minutes. So, it
Okay,
is
okay,
another
no,
5
okay,
minutes.
okay.
yes, sir. So, thank you, Gyan Mishra sir, for your address. With this, I would request Shri Jitesh John sir to deliver his special address and guide the stakeholders about how this IBC bill has been drafted and what are the major changes which have been inserted in this. Welcome to you, sir.
Thank you. Shri Charanjot Singh Nanda, President ICAI, Shri Gyanchand Mishra, Chairman Insolvency Valuation Standards Board, Shri Rajesh Sharma, Vice Chairman Insolvency Valuation Standards Board, my fellow panelists, CA Shri Jayesh Sangrajka, CA Shri Ashish Chaucharia, and Mr. Suharsh Sena, Ms. Sarika Singhal-ji, and all the participants of this webinar. First of all, I must commend the Insolvency and Valuation Standards Board for organizing this webinar of a very timely and relevant topic, which I think the entire insolvency community in India is sort of deliberating upon. So I commend the IVSB of ICAI and also thank you for inviting me to this very important webinar. As you all know, like the process started, I think many years ago, I think around November 2022, when there was a colloquium of all the experts of IBC. So a large part of the proposals which are found in the amendment bill arose from that colloquium. And after that, we had spent about almost 2 to 3 years. So the proposals were debated at large. They were widely consulted. The public were widely consulted. And then, I would say that the proposals were further distilled, and finally it has sort of come to this shape. So, even though the bill is piloted by the ministry, we at IBBI, including our chairperson, Mr. Ravi Mittal, he was very much instrumental in, you can see his imprint in some of the most important proposals which are contained in the bill. And I would say that we are now in a sort of at the cusp of what I would say a new trajectory. So far, we have spent about 8 years have sort of elapsed since the IBC has come, and by all, I think, yardsticks, IBC has fared much better than its predecessors. Even if we take the SICA or the DRT or the SURFACE. So by all yardsticks, IBC has sort of performed very well. So the statistics are all there out in the public domain. I don't want to repeat it. But now, we are at a juncture where our country as a whole is now taking a leap forward. This has been envisioned by none other than our Honorable Prime Minister, and it has percolated right down the government hierarchy. That we have now a target in sight. That is to be a Vikasit Bharat by 2047, and we have a sort of a significant role in achieving that. The world today, the world economy is completely different than what it has been in the last several decades. The countries are becoming more self-reliant. There are sort of many barriers in place. The free movement of capital and other factors which were facilitated by globalization has been impaired to a large extent. So we are on the sort of path of Atmanirbharta, as we all know. And the economic objective of IBC has been that, the resources which are stuck, which are the stressed, which are sort of, lying waste, IBC will be a sort of a tool to reinvigorate them, to revive them, and to, put them into better productive use. So this economic theory is most relevant right now when we need a lot of investment to become Vikasit Bharat. We need a lot of investment going forward. And IBC, by resolution of stressed assets, can release a lot of productive assets to the economy. And even if you see the banks sort of, whatever realization they sort of get from the IBC goes to their profits. They can again sort of, we all know the capital adequacy norms of banks. So whatever money goes back to the bank, it helps the banks to lend further. So the IBC ecosystem has a great role to play in this Vikasit Bharat endeavor. And so these amendments have come at a very sort of timely occasion. We have seen a number of articles in the media, several sort of, this thing saying that, stating about the objectives of why these amendments have come in, now at this point of time. A large number of these articles say that, it is largely to address the problems that IBC has been facing. I would say that is true to some extent, but I would personally feel that this is more of a futuristic, effort. It is rightly, I think, pointed out by Gyanchandra Mishra ji. It is like IBC 2.0. So, while some of the amendments, some of the, provisions are to address the problems which have been faced by the IBC so far, but if you see holistically, it is largely to, to bring out a paradigm shift in the way in which we are approaching the insolvency resolution. So I'm not going into the nitty-gritty of these amendments. All of you would have, read about this by this time. It's all out in the public domain. And I'm sure that the experts, Ashish ji and Jayesh ji and Swash ji, they'll be delving more into the nitty-gritty. So I'll just keep it, very general. So, as you can see, there have been, the amendments there. Some of them have been clarificatory, basically to, bring more clarity and, reduce ambiguity so that, litigations, because what we found is that, the single biggest cause of delay in IBC is the litigation. Like there are lots of litigations right from admission stage to the process stage, and even after completion also the resolutions are challenged. So these a large number of clarifications which are proposed in these amendments would, I think, help to resolve or to avoid many of these litigations and set the path right. And in this context, I would like to advise my the insolvency professionals that whichever cases which they are handling, like in most likely in the winter session, this will be passed and it will be a law by, I think, early January or so. So they can start preparing now itself in preparing this and all in light of these amendments, because I think a large many of them are clarificatory. So that will have retrospective effect that will apply on the ongoing cases. So they can start their preparations right away. And then there are many new initiatives like the group insolvency, like the cross-border insolvency. So these initiatives are like the code does not delve very deep into it. It has the code has left it to the Ministry of Corporate Affairs to bring out detailed rules for this cross-border insolvency and group insolvency. So here again, I think it would be a good initiative if this IP community can come together and sort of put your brains together and see how we can develop this framework, because the code it doesn't detail the framework. The framework will be sort of put together by the ministry. So in this regard, I think it will be very appreciative if the IP community can put, and not only the IP, the entire insolvency community can come out with suggestions and ideas on how to how to sort of bring out this framework. So this also, I think, a good opportunity. We would have enough time to dig deep into that and come out with solutions and suggestions. Then there are also many sort of places in the code where it has left to the IBBI to specify various things by regulations. So there also I would invite your attention to those parts of the code also, and prepare your thoughts and ideas on how they should be taken forward. So while preparing the regulations, while bringing out with the consultation papers, so we can bring them out without any delay. So if you're right away, if you sort of look into those aspects of the bill, so that will be very beneficial. And there is also like a ministry is also working on a IT system, so which is also like touched upon in the bill. So they're also like the IT, we need to come together as to how to it will be a very integrated system, and we have to sort of that would also help in very in efficient resolution and insolvency processes. So I would also invite your attention to that. So these are some of the broad things which I thought I will share with you in the inception. So I'm sure that this webinar will be a rich experience for all the participants here, because we have experts or panelists here who would, based on their experience, would delve into the finer print of the bill. And I once again thank the Insolvency and Valuation Standards Board of ICA for organizing this event, for this webinar, and for inviting me here. I wish this webinar all success. Thank you.
Thank you, sir, for your address and guiding the stakeholders about the amendments. I think that there's some more time for President sir to join, so we can initiate with the panel discussion with a brief about the panelists who are there. So we'll start with CA Jayesh Sangrajka sir, who has 38 years of experience in corporate finance, investment banking, corporate restructuring, private equity, etc. At present, Mr. Sangrajka is handling CIRP, having debts of over rupees 15,000 crores, impacting more than 10,000 home buyers and slum developers. We have Mr. Ashish Acharya sir, who has 27 years of experience And he has experience in diverse sector experience, includes industry verticals such as metal and mining, energy, banking and capital markets, aviation, manufacturing, healthcare, and real estate and infrastructure. He has been at the forefront of various engagements across India, representing numerous large lending institutions and asset reconstruction companies. Welcome to you, sir. Then we have Mr. Suharsh Sinha, who has 17 years of experience and specializes in restructuring and insolvency and banking and finance. So he represents resolution professionals, borrowers, institutional creditors, asset reconstruction companies, acquirers of distressed debt, and creditor committees on restructuring and insolvency proceedings, including interim finance, CIRP, liquidation, takeover, and related litigation. So, with this, welcome to you, sir. You may, I now hand over the session to you. You may start with the panel discussion, sir.
Thank you, Sarika ji. And before we start, many thanks to ICI as well as IBBI for facilitating this discussion. And special thanks to Mr. Jitesh John as well for sparing his time for this discussion. It's not often that we get the opportunity of interacting with so many professionals. And I think kudos to ICI for being able to arrange such a wide forum for discussion. So thank you very much, Sarika ji. And also, you just made me realize that I have the least amount of experience on this panel. So that's also a very humbling thought to start off with. Having said that, again, thank you for making me a part of this August panel. Before we start, just a few opening comments on what the industry, in my view, perceives about the bill. And then we can get into discussions. So I think, first of all, this bill typifies what is known, at least in more developed legislatures, as regulatory impact assessment. And I think that's a means of regulation and legislative drafting where the government evaluates the cost and benefit of every proposed amendment very thoroughly. And that happens not just through economic analysis and consultations, but very wide public debate and very wide stakeholder consultation. And in my view, the current bill that has come before the Parliament, thanks to the efforts of the MCA and the IBBI, I think it meets the gold standard of regulatory impact assessment the world over. And regulatory impact assessment is something which has been embedded into regulatory culture in many other countries. And it is very heartening to see that the MCA and IBBI has taken a proactive step of using regulatory impact assessment as a means of legislation. And just to expand on that, the amount of consultation that the IBBI and MCA has done is truly incredible. So, for example, the Cross-Border Insolvency Rules and Regulations Committee submitted its report in December 2021. The Working Group on Group Insolvency submitted its report in September 2019. There was a very detailed MCA discussion paper on the proposed amendments in January 2023. The IBBI published its report on the creditor-led insolvency resolution process in May of 2023. And besides that, IBBI has conducted numerous roundtables, discussions, and consultations with industry practitioners and numerous experts and stakeholders. And this bill has been more than 3 years in the making, with innumerable drafts and redrafts. So I think, first of all, kudos to the MCA and IBBI for not only conducting a very thorough evaluation of the pros and cons, but being able to come up with a bill which has finally seen the light of day. Of course, we are awaiting the JPC consultations and what happens in December. But I think this is a very, very strong starting point, and all of us in the industry are excited and quite obliged that the government is taking such a keen eye in a sector which is so critical for the economy. So going into the amendments themselves, so we had a discussion, Ashish ji, Jayesh ji, and myself. We had a discussion earlier, and we feel that there are 3 or 4 major buckets one can divide the bill into. One is where the government has taken cognizance of the concerns raised by various stakeholders on recent judicial developments. And some of the amendments which have come are trying to look at those legislative decisions and trying to see it from a more holistic legislative perspective to see if those can be amended in any manner so as to increase the efficiency of the process. Those include Rainbow Papers, which talked about secured creditors' rights, Amit Metallics, which talks about the rights of dissenting financial creditors, Vidarbh Industry, which talks about mandatory nature of a Section 7 application, the Baiju case, which deals with withdrawal of IBC under Section 12A, and independent sugar corporation on the CCI amendments. Second category is removing some bottlenecks and efficiencies which have crept into the process over time, such as greater COC control in liquidation, a moratorium in liquidation, smooth transition of the IRP to the RP, and lastly, introducing new concepts and codifying judicial innovations, which includes primarily and the most importantly, in my view, the creditor-initiated insolvency resolution process, group insolvency, and cross-border insolvency framework. So this has been one of the most comprehensive legislations that we have seen as an amendment to an existing legislation. I will initiate. I'll start discussions with Jayesh and Ashish soon, but I note that Mr. President ICI has joined us, so I'll hand over to the President. Good afternoon, sir.
Afternoon. Good afternoon, Surans, Mr. John, and Mr. Gyan Misra. Friends, I can say this Insolvency and Bankruptcy Code 2016, when it came, the main purpose was to resolve at an earliest. So due to timeline delays, due to problems, due to ambiguities, the problems were persisting. ICI also gave some suggestions, and I can say that Mr. Mittal and your whole team of IBBI had worked very hard, and a lot of things have been taken, and it was finally passed by the Lok Sabha on 12th of August. So here I can say the main issues were to expedite the process, improve the stakeholders' outcome, clarifying all the type of ambiguities. The definition I can say of secured creditor was also an issue. So that is now also clarified. And faster insolvency was the main reason. So faster insolvency and admission timelines, those are must, I can say. And with group and cross-border insolvency, I can say it will take to another heights. These are few things. So now our chairman is also there. We can request Honorable President, sir, for his address, sir. Thank you, sir.
Yeah.
Please, sir.
A very good afternoon, ladies and gentlemen. CA Gyan Mishra, the chairman of this board, CA Rajesh Sharma, the vice chairman, Mr. Suharsh, Mr. Ashish, Mr. John, Mr. Jayesh, ably managed by Sarika Singhal-ji, and all who have come here to go home more enlightened. It gives me immense pleasure to welcome you all to today's webinar on the IBC Amendment Bill 2025, Implications, Insights and Impact, a landmark step in strengthening India's insolvency framework. The Insolvency and Bankruptcy Code 2016 was enacted with the primary aim of consolidating and amending India's fragmented insolvency laws into a single framework. Its objective is to ensure a time-bound process for insolvency resolution while maximizing the value of assets, promoting entrepreneurship, improving the availability of credit and balancing stakeholders' interests. Over time, however, practical challenges, judicial interpretations, and evolving business needs highlighted the necessity for periodic amendments to keep the code effective and aligned with the global best practices. The Insolvency and Bankruptcy Code Amendment Bill 2025 seeks to address these gaps, simplify procedures, and reduce delays in insolvency resolution. A key thrust of the bill is enhancing certainty in the process, which is very important. For example, mandating strict timelines for adjudicating applications under Section 7, 9, and 10, and clarifying that once default and procedure requirements are established, tribunals cannot reject an insolvency application on extraneous grounds. It also strengthens the role of creditors by ensuring fair treatment of dissenting financial creditors and by making resolution plans more predictable and transparent, including provisions for oversight committees to supervise this implementation. Among the most significant reforms, the bill introduces a creditor-initiated insolvency resolution process, more effectively called as CIRP, an out of court initiation mechanism to handle genuine cases of business failure with minimal disruption and faster timelines. This adds flexibility and reduces dependency on overburdened tribunals. The amendment bill also provides for group insolvency, allowing coordinated resolution of debt return companies within the same corporate group, and lays the foundation for cross-border insolvency rules, an important step for global investor confidence and recognition of Indian proceedings abroad. In a sense, the Amendment Bill 2025 represents the government's attempt to make India's insolvency framework more efficient, transparent, and adaptable by introducing new processes like creditor initiated resolution, group insolvency, and cross border mechanism. While tightening timelines and accountability, the bill seeks to ensure faster value realization, reduce legislative roadblocks, and reinforce the code's core purpose, timely resolution, and value maximization for all stakeholders. Together, these reforms reflect the government's resolve to make the IBC more efficient, transparent, and adaptive to modern business needs. They reinforce the code's fundamental objective, timely resolution, value presentation, and stakeholder balance. To conclude, I understand that this webinar provides a valuable platform to deliberate on these reforms, their practical implications, and long-term impact on India's insolvency landscape. I am confident that the insights shared today will help strengthen professional practice and contribute meaningfully to the continued evolution of the code. I extend my best wishes for fruitful and engaging deliberations. May the discussions deepen our collective understanding and reinforce the IBC as a pillar of economic resilience. I'm thankful to all the speakers and particularly the board for inviting me here. I appreciate the efforts of C. Gyan Mishra and C. Rajesh Sharma, because of which the webinar could see the light of the day. Thank you. Thank you so much.
Thank you, sir. Thank you very much.
Thank you, sir, for your enlightening address. With this, sir, we can start again the panel discussion. Over to you, Mr. Swash.
And Sarika, before the deliberation starts, let me thank President, sir, and for the information of all the participants. We are very soon coming up with the date and location of the Resolve 2025. We have submitted our request to President, sir. So Resolve 2025 again would be more marvelous, more wonderful, and more attractive than the previous two editions. So stay updated. Very soon you will get the date and location for the same. Thank you.
Thank you. Thank you.
Thank you, sir.
Thank you.
Mr. Swash, over to you.
Thank you, Sarika. So I think without further ado, let's get into the panel discussion. My first question is to Jayeshji. So Jayeshji, since you've done so much of work in the real estate sector, including on real estate group insolvencies, so my first question to you is, how do you envisage, first of all, at a larger level, what do you make of the amendments and what impact do you think that will have on the larger habitat and especially from the perspective of ease of doing business? And then my second question to you would be, and depending on, I leave it to you, Jayeshji, how much time you want to spend on it, on the group insolvency enablement that has been made in the amendments, because that's something for which rules and regulations are expected, but at least an enabling clause has been inserted in the amendments. So on your views on both the broader impact and secondly, group insolvency and how you envisage that to pan out. And you can probably help us also through your examples on the real estate insolvency that you have worked on.
So thanks, everybody. Good afternoon, everyone here. Thanks, our President, Nandaji, Mr. Gyan Mishra ji, Rajesh ji, Sarika ji, John ji. It's my privilege to be here today to share some of my thoughts on the Insolvency and Bankruptcy Code Amendment Bill. I would say it is a substantial reform bill of 2025. And to understand the significance of this amendment, I think we should go recall the journey of the IBC itself. I have been RP since year 2018, 2017, and I've seen most of the part of the journey of IBC so far. 9 years journey, 7, 8 years I have been part of this journey. IBC, as we all know, was introduced in year 2016. It replaced patchwork of laws that were slow, fragmented, ineffective, like BIFR, DRT, S4E, etc. So the IBC brought in a single time-bound creditoring control framework. In many ways, it was a game changer, helping banks recover large debts, disciplining errant promoters, and creating an entirely new profession of insolvency professionals and regulators. Regulator IBPI. This is very critical here for all chartered accountants here. This profession is seeing more than 65% of insolvency professional as chartered accountant. And regulator IBPI is one of its kind in world. No one can know, but however, a lot of learnings have happened over a period of 9 years, and no one can remain static. No law can remain static. Over the last 9 years experience, I'm sharing my experience only, has shown where the code worked well and where it needed refinement. Issues such as delays in resolution. I have resolved more than 30 cases and more than 30,000 crores, affecting more than 30,000 home buyers. And in each of the matters have been resolved, but there were some delays, there were some litigations, challenges in group insolvency. Like the question posed to me is regarding group insolvency. I am handling 3 matters of group insolvency. One is Darshan Developers, where the resolution plan has been approved. It took more than 36 months to resolve this 11 companies. It was one group, one slum project at Juhu in Mumbai, where more than 6,000 slum dwellers were not getting their houses for last more than 15-20 years. So I'm really proud to say this, that because of only IBC, this Darshan development matter has been resolved and order has been passed on 27 June 2025. So this involved 11 companies which were consolidated, and I thanks our judiciary also to understanding the why this group insolvency was required. So they appointed me as a common RP, and then there was a resolution of 13,000 crore claim, which is now the plan is getting implemented. See, other 2 matters also, the work is in progress. One is Sigitia Group and one is Avenue 54 project, where it involves 4 to 5 companies, where consolidation of all the resolution of all the companies is happening. And the matter will be, if this law, which amendment which are being provided under this reforms, if this law was there, the movement would have been much faster. But I think in some way, we as an RP also have contributed to this development of this group insolvency concept. Like some of the matters like Videocon, some of my matters maybe they have guided our regulators how to take up the group insolvency cases. So this is a remarkable achievement because this has all happened because of collaboration between all 4 pillars of IBC. So all this has been possible only because of professionals like resolution professionals who have worked at ground level, implementing the law and highlighting the practical gaps. 1,000 so far we know that 1,200 plus resolutions have happened. 3,000 plus liquidations have happened, and huge recoveries for lenders are there. The NPA levels have decreased from 13% to 2 to 3%. I have resolved around 30,000 crores. It means what? It means that it adds economic value to the projects. When Mr. Suhas mentioned that I have done most of my cases are real estate. So if I consider, I have not resolved 30,000 crores. It is more than 1 lakh crore of economic value what we add. For example, my project at Vinanagar, Aristo Developers, I humbly submit all of this. I'm just sharing my thoughts. It's not my only. It has been a collective effort because of the law, because of IBBI, that I have been able to achieve this. But like Meenanagar project of which Prestige, which is one of the largest developer in India, took over. They have implemented the plan. More than 700 home buyers are getting home. This has been possible because only of IBC. So same way at a larger macro level, the NPA levels have decreased. Only reason is that fear of IBC, resolutions under IBC, and now we are seeing that backlog of cases have also decreased because of the efficiency of judiciary also. So, however, some challenges will always remain, and I think I have shared my view on this, Mr. Suhas. Anything further, I will add, contribute later on.
Thank you, Jayashree. Thank you very much. I'll come back to some of the threads that you touched upon, but before that, I have a question for Ashish. So Ashish, in particular, there's been a lot of interest on the creditor-initiated insolvency process, which I think the foreground of which was the creditor-led insolvency resolution report, which IBBI had published. So your thoughts on what you see in the bill, and where do you think the opportunities are, and where do you think people should be concerned in case there are any pitfalls?
Thank you. Thank you, Suhash. Thank you very much to the IBSP and ICAI for giving me this opportunity. And it's a pleasure to be amongst such an august panel here. And Mr. John, pleasure to interact with you once again. I do look forward to engaging conversation here, and both sharing some from my experience and also learning from the various panelists here. Before I proceed, I'd just like to clarify something. While Suhash mentioned at the beginning that he has the least experience amongst us, but given the amount of double time he works, I think it's probably you're probably more than what we are experienced. So it's a pleasure to be here with you, Suhash. So your question specifically on on the creditor initiated insolvency process, in short, CIIP or CIIRP as it's been referred to. This is truly something that we have been waiting for a long time. I think one of the criticisms around CIIRP has been the time that is being taken in the court-led process because of the various interventions at the courts, the time that is spent and the destruction of value that one has seen in companies happen. I think what this is trying to do is address a large part of that. Of course, it has its sort of checks and balances, and very, very well drafted, I must say. I've not been involved in this particular committee who's made this, but I can say that, I'm sure a lot of hard work has gone behind this, a lot of thought has gone behind this. There's some really good sort of nuances that have been placed in terms of who are the eligible corporate debtors, who are the eligible FCs. It's not all encompassing. It is not something which is proposed to be, just swept through the entire, CIRP process. It's not undermining CIRP at all. While the bill today has not really specified the criteria of which corporate debtors are going to be eligible, but it's clearly mentioned what there will be certain parameters which the central government will stipulate. I'm only hopeful that it will not be a very low threshold, because what would happen, what we have seen in the earlier example of fast track, somehow it did not get enough sort of cases for testing it fully. So I hope that the thresholds that are defined, for this CIIP, it should be covering a fairly significant number, or at least value-wise, of cases to be really testing how this works out. Otherwise, it'll remain a theoretical exercise. I think a great concept of eligible FCs, eligible financial creditors. Again, what exactly that will mean is not, is not clear at the minute. But the eligible FCs, and that too with checks and balances of, a lower threshold, 51%, by 51% approval, for them to be able to initiate this process. So it is supposed to be, it is designed to be a well-balanced area. It gives enough opportunity also for the corporate debtor. So there, the principles of natural justice are being followed. One, it clearly lays out that the FC will give a 30-day notice, and then even after they receive a representation, they have to further deliberate within the eligible FCs whether such a process can be initiated or not. And thereafter, a resolution professional is appointed. And here, again, there's no need to go to the court for admission process, so on and so forth. There's a right for objection. Any corporate debtor has a right to object to this process, and in which case, courts will then decide either, whether it is a sort of eligible case for CIIP, or maybe even move it towards CIRP. So I think, what's really, the occurrence of default, of course, is a mandatory requirement. But I think the very important principle of, the debtor in possession and creditor in control, because we have seen a lot of companies and promoters in the past have complained about the destruction of value in their companies the moment a CIRP is initiated. I think while this is not going to address all of the concerns they have, but I think given the fact that the company will still remain in the possession of the debtors and the management with an appropriate oversight by the RP, who's going to be present in all the board meetings, management meetings. I think the role of the RP is going to be becoming even more important, or let's say equally important, because here, earlier RP was superseded the board, so the powers of the board was subsumed with the RP. But here he has to very tactfully manage what's happening in the board meetings and the management meetings, because the company is still in the possession of the and the role of the RP will become, I would say, he or she needs to really balance the role very well, because at which stage the RP will file, with respect to if the affairs of the company are not being carried out in the best interest of the creditors, how he balances his judgment. These things will become, very, very important. So I think the role, this process, it cuts down time, by excluding the entire involvement of the courts or tribunals at the initiation stage itself. And in various places, the thresholds have been amended. What kind of decision making, by it puts a checks and balance about, how the plan would be approved, 66%, etc. So I think another important thing in the code doesn't really specify anything about a Swiss challenge mechanism, which was there in the earlier sort of fast track prepackaged insolvency. But here, it doesn't really specify that, which would mean that it can be determined on a case-to-case basis, I presume, how it needs, because that was another area which was concerning with respect to the time being spent in the process. So I think, we're all very excited about seeing what this really means, how it helps the resolution process. The role of the RPs will have to become a lot more business-like, because this is going to, the corporate debtors in many of these cases, I presume, will also be operating companies, not just defunct companies. So, yeah, interesting. I think very interesting times ahead. Back to you, Suhash.
Thank you, Ashish. So just a couple of my own observations on the creditor-led insolvency process. I think it's first point, I totally agree with you that the sort of companies that it should be introduced for should, in my view, be large companies. Because in pre-packs, what we have noticed is that the government has been cautious, and rightly so, and started with small companies first. And unfortunately, we have not seen too much of an uptake in pre-packs. And the primary reason, in my view, is that small companies already have a very simple capital structure. So they generally have one or two lenders, and those one or two lenders are the primary lenders, and they have a very close relationship with the borrower and amongst each other. So the sort of complexity which a pre-pack tries to deal with is not present in small companies. And I think creditor-led insolvency process is an even more sophisticated mechanism than a pre-pack. So this will be of use, in my view, to companies which have significant amount of size and a very complex capital structure, where you have banks, NBFCs, NCDs, secured and unsecured debt with security, with different levels of security. So that's the sort of company where I think CLRP, I'm calling it CLRP for the sake of convenience, is really attuned to. Secondly, I think what we have tried to do with the CLRP is try to achieve a very fine balance between letting the promoter or the directors remain in control so that value is preserved, at the same time have adequate amount of supervision and control from the committee of creditors and the RP, right? And the third dimension to add over there is price discovery. So I think these are the three elements which we are trying to balance in a pre-pack, because you want the promoter to continue in certain cases. At the same time, you don't want the promoter who's 29 and disqualified to continue with the company. The way one can read these two together is that 29A prescribes that an account needs to be an NPA for more than 1 year. Therefore, the moment the default occurs, the expectation is that the promoter cooperates with the lenders to initiate the CRRP process, because the promoter at that stage is not debarred under 29A, and therefore it is an incentive for promoters to come forward and engage in this process if they have nothing to hide.
Yeah.
Sorry, please
carry on. No, carry on.
And on price discovery, so even in this process, the idea is that the RP will conduct his diligence and issue an information memorandum, and bidders can potentially come and make a bid. This is where I feel CLRP departs from pre-pack, because in pre-pack, the promoter gets a first bite because he gets to propose a base resolution plan. Whereas in CLRP, from my understanding, unless the regulations and rules clarify otherwise, there is no base resolution plan as such. So I would request the government and Mr. John, I'll kindly request your attention on this as well. Whether the fact that the base resolution plan is not allowed to be proposed, will that be a disincentive for the promoter to cooperate with the lenders? Of course, if the lenders want to initiate it, they can do so. They have a statutory right to do so, there is no doubt. But to make it even more promoter friendly, if we can have elements of a base resolution plan which exists in a pre-pack, if those elements can be incorporated, maybe it's worth your consideration. So, but sorry, Ashish, back to you. Unless
no, I was just saying we should probably hear from Mr. John as well,
yes,
because
yes,
he's seen what happened in the pre-package insolvency, and now with this, I'm sure the inputs from IBBI will be very important.
Yeah. So, insofar as creditor-led insolvency process is concerned, so this is it is basically a subset of our overall sort of the philosophy of the insolvency resolution, where a creditor initiates, it's basically, it would largely fall under the Section 7 gambit itself. And why we have restricted is because, there have been a lot of concerns whether, this kind of resolution, which is basically, out of the supervision of the adjudicating authority, unlike in other cases. So in other cases, like the NCLT oversees the entire process. So here, it is basically an out-of-court mechanism. So there has to be adequate checks and balances. So that is why, we have stated that, it will be applicable for a set of companies and creditors, which will be notified later by the government. So that obviously, like, the ministry will sort of, in consultation with the stakeholders and us, will decide like what would be the type of companies and what would be the type of creditors who will be eligible to avail this process. And insofar as the specific question is concerned, like as of now, like as I told you, like we try to fit it in within the current sort of overarching framework of this CRP. So creditor himself proposing would be a bit sort of a departure, I would say. But nevertheless, we will certainly, we'll consider it here within our team and with MCA. Your suggestion, I'll certainly pass it on to them.
Thank you, sir.
Suhash, before you proceed, maybe we can request the audience and participants that in case they have questions, please do add it to the chat box. The way we have planned this afternoon is that we are going to leave sufficient time for taking your queries rather than you being here just to listen to us. So if you have questions, please do put it on the chat box, and someone will be collating and sharing those queries with us maybe in the next 20-25 minutes. Thank you. Suhash, back to you.
Thank you. So, Jayashree, I have a couple of more questions for you. So, in terms of the broad learnings from these amendments, Jayashree, in case you have any specific comments on which of these amendments you particularly find would be very useful. Those may be in terms of the case laws which the legislation, the bill seeks to address, or it could be on some of the inefficiencies. In your view, which one of those one or two amendments would you think of will make a big difference?
So I think the very big difference will be the admission stage. Nowadays, we all know that it takes 1 or 2 years to admit a particular CIRP process. So this deadline of 14 days will be a game changer according to me. And even the orders which are getting delayed as on today. See, the major concern for all the investors is the timelines and time value of the money. If cases get admitted so late, 2 years, and then CIRP process will take another 2 years. And if the company goes into liquidation, another 2-3 years. So this whole process gives discomfort to the investors, large investors, private equity funds, FDI, etc. So this timeline issue is being addressed, according to me, by this amendment. 30 days you have to, after filing the resolution plan, within 30 days, the orders should be there. I don't know how NCLAT and Supreme Court will react to all of these timelines. But having said this, I think this timeline issue is a major thing, a game changer, according to me, for the investors, which will protect the time value of money, and it will attract more investment in Indian economy. So one is the timelines issue. The second is this pre-pack issue for large entities. Pre-pack is really a game changer. Every country, see, we are talking about arbitration, mediation, etc. So pre-pack, in a way, if FCs and that is also designated FCs and designated creditors, debtors. So they sit together, 30 days time is given, they work out a plan, and some strategy will be worked out, and there can be some resolution. So this pre-pack CIRP is also a very good amendment. And the third thing regarding this group insolvency, I have already mentioned that my one matter has already been resolved, another 2 are in process, and group insolvency will definitely help real estate projects, infra project, even large manufacturing units. This will enable faster resolution of group companies and settlement of all the liabilities of the group. And this will give a lot of confidence to the investors. This is and financial creditor. This is my view.
So, Jayesh bhai, on the group insolvency topic, when you say about, it'll benefit, the investors, the creditors, can you share a couple of examples from your experience how the group insolvency helped in your case as compared to not having it? I mean, so that for the benefit of the audience, that will be, very useful to see how do you relate that, from the legislature to practice.
So, Ashish bhai, if I talk about real estate projects, what happens is there are joint development agreement, land rights in some company, project is in another company, sale home buyers are in one company, home buyers are not there in other companies, and group of promoters come together, they form a company holding 50% shareholding, and there are execution rights with another company. So all this type of things in real estate can be resolved only through group insolvency. This is the practical challenge, which is particularly relating to real estate. as far as other manufacturing units are concerned, and plus what happens in my case, for example, there was 1,25,000 meter of land which was subdivided into, and that too the division was totally not as per the boundaries were not earmarked, and the development would not have happened unless there was a group in insolvency, and there was only one regulatory authority, SRA, to pass the proposal. So all these cases, this group was created only for, sometimes groups are being created only for financial engineering, which I don't want to debate or get into here. But definitely group insolvency provisions, whatever have been provided, will help in faster resolution. That is what is my view.
Thank you, Jayesh. So, Jayesh, on the first point you raised on the timelines, I think all of us in the system are very aware how there's a negative relationship between the time taken and recovery. So, I think to the extent in the past also, when the code prescribes certain timelines for the judiciary, unfortunately, higher courts have held that they are directory in nature. But notwithstanding that, I think the fact that such timelines are inserted in the legislation, it does impose some sort of a judicial discipline. So I concur with you. I hope this leads to some sort of adherence to timelines by the judiciary.
But it is comply or explain, right? I mean,
yeah.
Yes, it is. It was always supposed to be there. Timelines has always been there. Somewhere along the way, I think, it started slipping in directory, not mandatory. Various things started, letting. I remember the earliest cases that, all of us have been involved in, like 16, 17. It was literally, between 10 to 20 days is when we had some of the largest cases getting admitted. And there, the threshold criteria that was to be seen was purely, is there a default or not? And is the RP eligible or not, right? Or the IRP is eligible or not? I think it's back to the old times in some ways. And it's comply or explain. So at least it puts some accountability, right? I mean, no one can force them. There's so many things we can't envisage why things take time. But I think the other relation to that is also about, this, there's an inclusion about vexatious litigation, right? I mean, frivolous litigation and more powers with the courts and tribunals to impose penalties. At least in my experience, and I know, Suhash, you have probably much more experience in this matter, but litigations in this process, a lot of times has been seen to be just unnecessary and frivolous. And we all understand natural justice, principles of natural justice, but many a times it has been used, to the benefit of one party, and to frustrate the process. So hopefully some of these things will bring back, timeline into the focus.
So,
but there's some counters to that as well. But yeah,
if I can add, see, timelines can be adhered only if judicial infrastructure is strengthened. If judicial infrastructure is not there, how are the cases going to be resolved? How are the timelines going to be adhered to? That is one major thing. And I think nowadays the things are moving much faster. This is my personal experience. So things have started moving much faster last 1 year in court functioning and all that. So this is where the major concern is judicial infrastructure. If proper support is given, then I think timelines can be adhered to. If there is no proper infrastructure, then these timelines will be very difficult to adhere to. That is what is the view. As we all know, number of cases have decreased. But this is an economic cycle. The cases may increase in future. We should have adequate infrastructure, and that is the only way timelines can be adhered. This is my view.
Thank you, Jayesh. And in fact, on timelines, one of the amendments which has been introduced is that if there is inter-creditor dispute under a resolution plan, then at least the plan can be approved and the funds can be kept in escrow while the litigation is pursued. So that I think is a very notable change as well.
But on that, Suhash, I have a question for you. How do you see that playing out practically? Because, yes, I agree. It was already, referred to in the last regulatory amendments, regulations that were amended, that you can do it in a two-stage process. But practically speaking, it is how will it play out in your view? It'll be good to hear that, because what I've, the creditors, the committee of creditors are also responsible for agreeing or approving on the distribution, right? Now we have enough judicial precedents as well as regulatory guidelines on this, that it's the COC who are responsible for deciding the distribution, manner of distribution of the resolution plan proceeds. The same COC members are also going to approve the plan. In my experience, I have seen many times where the COC members, for whatever reasons, they are of the view that first I would like to see what am I getting in this plan. Then accordingly, the plan is going to get approved or not, right? So how do you sort of distinguish the two? I mean, we have done some, we have tried out some innovative things to try and make it work. Also parked some proceeds, pay out minimum of the two, based on liquidation value or voting percentage, various formulas to try and placate or manage the situation so that the resolution can proceed. But end of the day, if the COCs are not agreeable on the distribution, do you think they are going to actually approve a resolution plan to proceed? Do you see that happening? So
that's a very good question. No, I think that's a very good question. I share your concern, because it's very difficult for boards, especially PSU banks, for them to go to their boards and to get approval for voting on a resolution plan until such time as they know what is the payout they're going to receive under that plan. Now, if the payout they receive under the plan is subject to litigation, which will pan out after a few weeks or a few months, it's difficult for them to vote on the plan today. So I think where there are multiple plans, where there's more than one or two plans, it'll be difficult for lenders to take the benefit of this amendment. But probably when there is only one plan, and the only question is how the proceeds will be distributed, and if you don't approve the plan, then the company is likely to go into liquidation. Maybe in that limited sense, this amendment could be of use. But if there are multiple plans and there are serious differences amongst lenders, I think this amendment will require a lot more thinking before it can be of great use. I mean, recently we have been involved in some cases where we adopted a mechanism where the lender said that the plan can be approved, and they contractually agreed, and they passed a resolution to agree that the distribution of proceeds can be addressed at a later stage. Now, that was an arrangement they entered into contractually. Because in that particular case, it worked for them to be able to at least approve the plan. Because if the plan is approved, then their payout, even if they dissented, their payout was going to be higher. So it was in their interest that the plan gets approved. And even if they get a lower value than their ideal agreed value, at least it was still more than liquidation. So I think in that limited circumstance where they feel in either case they're getting more than liquidation, then I think this amendment will be of use. But if there are serious intercreditor disputes, then I think this amendment may not be of use unless the amendment which has been made in relation to Amit Metallics comes to the rescue, which is, I think, a very good sort of way to segue into that amendment, Ashish. And that's something which you and I have struggled with in the past as well. And I'm sure Jayeshji will also have his views on the... So Amit Metallics, again, for all the listeners, Amit Metallics basically said that the priority of security is not relevant when you're deciding the payout of dissenting financial creditors. So even if you are a secured, 100% collateralized dissenting financial creditor, you will be forced to take the same haircut as the assenting financial creditors are taking, which means that even though you may be entitled to 100% recovery in liquidation, in a resolution scenario, you will be getting a 40% recovery, and that is forced upon you. This judgment was thought to be overturned by Ruchi Soya. But of course, they were both benches of coordinate strength. and therefore the matter has been referred to the CJI for constituting a larger bench, which has not happened yet, and it's been more than a year. So the amendment, Ashish, which the government is introducing through the bill, let's discuss that. And in your view, do you think it goes far enough to undo the damage done by Amit Metallics?
Yeah, thank you. I think you've highlighted a very, very important change here. I think two things here. One is, of course, what is a dissenting financial creditor or DFC entitled to in the event of if they're dissenting in the plan, what will they be getting? And secondly, another big issue that that has led to a lot of disconcert between the creditors is the issue of what happens to the inter se sort of priorities of creditors in the scenario of liquidation, right? So whether if someone is a subordinate, charge holder, second charge, third charge holder, based on various jurisprudence, I think the views that were being taken in the recent past has been that the creditors, once they relinquish their charge, they would all become pari passu. Once they relinquish their asset to the liquidation pool, they would be treated as pari passu. I think that has sought to be corrected or rectified here, where I think, from my reading of the bill, it seems that the inter se priority between the creditors would be recognized. I think that is very important for the entire sort of banking framework in my point of view. Just because a liquidation commences, it doesn't mean that a creditor will lose their rights or priority in a particular case. But coming to your earlier point, and both these are related somewhat, because when you're computing what a dissenting financial creditor is entitled to, one has to take into account all of these factors, right? The amendment here, which you're also referring to, about what would be a DFC entitled to in the event of dissent. Here, the amendment, what it says is that lower of what they would be entitled to in the event of liquidation by way of the liquidation, based on the liquidation value report, or what the resolution plan, what they'd be entitled to in the resolution plan. So there's no perverse incentive for a creditor to dissent just because, based on the valuation report or the liquidation value given by the registered valuers, they would in theory expect to get a higher number, right? So the lower of the two is what now this bill proposes, which would kind of remove this. We have seen this play out in many cases where it says, I'd be dissenting financial creditor would get the minimum of liquidation value. And the liquidation value, I think there's been a lot more focus and on the liquidation valuation reports. Not that it was not there earlier, but I think now it comes a lot more into focus as well, because the valuation reports would be put to test, more frequently. So I think a very important change, I think, goes towards the towards promoting more resolutions, because it more and more creditors were looking at if I get more in liquidation, then why not? What stops me, right? From their perspective.
So on that note, Ashish, I think there are two very important threads you've touched upon. One is the fact that you will get paid lower of liquidation value and resolution value, which I think is also another interesting change made by the bill, because earlier there was a confusion as to what will happen if the plan value is less than the liquidation value. Because the plan value was less than the liquidation value, then the dissenting financial creditors would still insist that they deserve to be paid as per the liquidation value, which would often mean that there was more of an incentive to dissent, especially when the plans were of lower value, which would put the company into liquidation. So I think this amendment certainly addresses that. The second amendment, which is also, I think, relevant for in this Amit Metallics context, is that in a liquidation scenario, the value to which you're secured, that value is now it says that it should be the value of your security.
Yeah.
Right? Which essentially means that if you are under collateralized, right?
Yeah.
Then you will not be held to be secured for 100
The
rupees.
entire value. Yeah.
Exactly. If your security is worth only 10 rupees, then you're secured for 10 rupees.
Yeah.
Conversely, if you are secured for 110 rupees, it does not mean that you get more than the value of your debt. Right? You are secured to the extent of 100 rupees. So this also, I think, goes to some extent.
You're right. And we have seen some case laws, in some very significant cases like IL&FS, for example, where, the NCLAT actually put out the distribution plan, approved the distribution plan in this manner, whereby the security, to the extent of security, you are considered secured. But you're right that in the code and in practice, there were a lot of ambiguities. So just because of what NCLAT did in some of the cases, it was not being practiced across. Now with this amendment, I think this brings in a lot of clarity in this process, and I think it's also right, because we have seen cases where. Suppose you have 100 crore outstanding and you're collateralized by a 5 crore, let's say, FD. Suppose it was a BG and, it devolved and so on and so forth. And you had a margin money of 5%. That doesn't make, unfortunately, that party to be secure for the entire 100 crore, right? So I think this amendment really sets the sort of waterfall correct. So, but yeah, it'll be good to hear your views as well, Suhash, and how you see this playing out.
No, I have a couple of thoughts on this, but Jayeshji, I'll let you also share your thoughts. This amendment in particular and the impact you think it will have.
So there are two things. One thing regarding this voting. Now, voting on plan on the plan and then the distribution. I think that's a very good move, because ultimately bank, PSU bank or whoever are involved, their board also will have to consider the commercial wisdom. If they delay the approval of the plan, the value of the NPV of the amount also decreases for them. So at least the amount goes into a escrow account and they will approve the plan. And let litigation be resolved subsequently. And voting on the plan, on the distribution can happen subsequently also. So this is my view. So ultimately they will also have to consider the commercial wisdom. If the amount involved are huge, and if some amounts are getting deposited in an escrow account, why should any creditor object? And similarly, if there is now the concept is very clear about this dissenting creditor. So they will also not like to be a dissenting creditor, and they will vote on the at least on the plan also and distribution also subsequently. So scope of litigation will decrease according to me because of this amendments.
Thank you, Jay. On the point of sorry to go back to this point of security value, because I think that's something, in my view, that is the biggest inter-creditor dispute, which always comes up. Unfortunately, what was happening was that a principle-based approach was not being taken, especially by the largest lenders in the country, because they would often evaluate which methodology works for them best in a particular case. Wherever they felt that linking it to their particular security value is beneficial, they would choose that approach. Wherever they felt the pari passu approach is more beneficial, they would choose that approach. So I think with these amendments, we'll have more responsible and principle-based approach taken by lenders when it comes to the question of distribution.
Right.
Jayesh, I have one more question for you. And in fact, for Ashish as well, and I'll let you decide, who wants to first take a crack at it. But Jayesh, especially in the context of real estate insolvencies, we have seen that a lot of 12A applications are made, particularly in real estate insolvencies. So the amendment which has been made to 12A, saying that the withdrawal can happen only after COC is constituted and before EOI is released. What are your views on that amendment?
I think this is a really good amendment. I will share my experience. One
Yes.
I was handled by me was Kakade Estates, which is 12A matter. It was resolved after more than 1 year. 12A application was filed because there was a stay also that Form G cannot be published and all that stuff. So after 1 year, and COC was constituted after 1 year 12A application, and Honorable NCLT approved it. So, and I've seen many cases where, once the case is admitted, this CD will come around and then try to settle the matter. Then what happens to other creditors? What happens to claims of other creditors? There are many litigations in a particular case, and one particular matter gets admitted, and he, after 15 days, resolves it, and there is no COC constitution. What will happen to the litigation which have been initiated by other creditors? So this amendment definitely is a good amendment, and 90% approval, like in some other matter also which I am handling, which is some 5-star hotel, where also similar situation is there. 1 year back, case got admitted, then there was a stay from NCLAT, and then there was discussion on settlement, and now again it is in CIRP. So this all process, 12A amendment is definitely good for COC, all the COC members. That is what is my view.
Over to you, Ashish.
Yeah, no, I think, on timelines, I think, 12A becoming stricter, because what was being perceived so far is that I would rather say what the practice had almost become is that a resolution plan, a 12A application by the promoters or a 12A related, withdrawal process almost became like a resolution plan to compete with, from the other external sort of PRAs, right? It almost felt like, a promoter's plan can be there right through the process. So by defining the timelines, I think it puts a lot of focus, a lot of, that beyond this time, it cannot be exercised. It was already there in the regulations. I think now putting it in the law as well makes it more sacrosanct. So I think it's all in all very good. I think, moving from there, of course, we have spoken a lot about timelines, and before we move to some other topics, I would like to state one amendment which, to my mind, goes to the other direction, which I'm sure there is good rationale behind this, but this thing about restart and reinstatement of CIRP, right? With where the courts can restart the CIRP and allow for another 120 days. Plain reading of it, to me, looks like we are kind of extending the CIRP process one more time. And, after this, we still have the sale as a going concern. Then we have, 230, 232s, liquidation as a going concern. So where does one draw the line? I was just thinking about this, that is this, are we, by virtue of this change of, reinstatement and restoration of CIRP, yes, avoiding liquidation is definitely, a very important intent. Finding a resolution is an important intent. But one has to also see the economic value, what will remain. So if we cannot do it in 180 days, 270 days, 330 days, another 120 days for restarting or restoring the CIRP process, is that going to really lead to benefit? Because what we don't want to see is this becoming a default, right? Specific cases, special cases, yes. But if it starts becoming a default, then, all we are doing is extending the timeline in this process. So while a lot of changes in the code talks about, bringing back attention into timelines and, comply or explain, but this one, to my mind, looked like going a little bit on the other direction. But yeah, I think I don't know whether you have any views on this, Suhash.
No, I agree with you, Ashish, and I think in the interest of after you reply, please. Yeah.
I will like to add similar situation I had in one matter which is called SK, like, which has been resolved. So COC did not approve the plan; it went into liquidation. After the petition was filed, we got a RA and we applied to NCLT, and NCLT allowed us to restart the CIP process. Gave us time, limited time of 60 days, if I remember correctly. And the plan was ultimately approved by COC, and ultimately it was also approved by NCLT. And then the matter went up to Supreme Court also. So this 12, this process of 180 days, 90 days, and 330 days plus 120 days, but ultimately objective, if the COC desires and if there is some resolution applicant who can take over the particular unit or a project, then why not? A second chance, and this is only for one time. So it's not that it is going to happen. Even if you are not able to resolve within 120 days, the other process will start. So I think this will give you a chance where, for some reason of infighting between COC or whatever reason, there were no better plans, and COC voted against the plan. At least after that, after you file you file for liquidation, and then you are given 120 days if COC approves again to restart the process. So I think this is a good amendment in certain cases. Yeah, it should not become a default as what Mr. Ashish Bhai said, but I think this will work.
Sure. So I think in the interest of time, maybe I'll just request for Jayesh Bhai and Ashish to mention one amendment which they feel should have been introduced but has not been introduced, or alternatively an amendment which you feel needs some rethinking.
So I think, if I may go first, I think what needs a little bit more thinking and clarity is, on that amendment which spoke about continuity of all the licenses, approvals, and government concessions of the corporate debtor associated with the, approval of the resolution plan. I think it seems to be too wide, and how this will be implemented, how much this will be, subject to challenges by, there's so many, licenses, authorities, land authorities, how, I mean, in principle, I think it's a good thing that the corporate debtor starting a fresh, clean slate should have the tools and wherewithal to revive the company. But making it into a legislature like this, I'm not able to envisage whether implementation of this, how this is going to pan out. I think, and I'm happy to, I mean, it's still very early days. I'm still to, maybe I've misinterpreted this slightly. I'm still to discuss with a lot of other stakeholders what they think. But I just thought, since you asked the question, I thought I'll bring this up.
Sure. No, thank you. That's a good point.
If I have to add, since relating to real estate projects, if there are multiple projects in a company, and there is no, if there was a provision for carving out a particular project, I think that will help a lot. That is this particular amendment. If somewhere it is done, it will be good. I hope you get my point. Suppose there are 5 projects in a company and one project is not doing good, then whether that express provision in the law would be helpful.
See, there is a provision now that has been introduced that, resolution would also mean, selling of an asset of the company, right? Which is a beneficial provision to the extent, where there are large diversified companies, and if there are multiple businesses or locations in it, you can carve it into, separate parcels and do the resolution, which would still qualify as a resolution, not just CD as a going concern. But I think what's probably not been, at least to me, is not very clear, that suppose you sell the economic value in the business, which is of attractive economic value to the bidders, what do you do with the remaining corporate debtor? Can you put that into liquidation? If you have a corporate debtor which has got a defunct, invaluable sort of business, would it still be okay if you do a asset-wise sort of resolution? Can the RP then put the rest into liquidation? I think this would really play out, and this happens in the pre-pack regime, etc. in UK. Suharsh, you know that, right? The economic value, the whole business undertaking is transferred, and the corporate debtor is then dissolved or put into liquidation, and both these are considered perfectly legit acts. So, but what's your view, Suharsh, on what an area where more thought could have been put?
So I think, I mean, on Jayesh Bhai's point, I think it's conspicuous by its absence, because earlier there was a discussion on real estate insolvency. There was a discussion on real estate insolvency, but we haven't seen that amendment come through. And I understand why, because the amendments proposed on sector-wise or project-wise insolvency and how to break up a company, they are quite innovative. And I think a lot more thinking is required before they are put into place. But I agree that's an area which still remains unresolved. My particular concern is around liquidation as a going concern, because that is, in my view, a negative judicial innovation. Because liquidation by definition means that a going concern resolution has not been possible, as a result of which you're putting the company into liquidation. Because now we see resolution plan like sort of schemes which are proposed in a liquidation scenario, where the shareholding transfers, the permits and licenses, consents, everything transfers in a liquidation sort of resolution plan as well, which I don't think is legally very sound. Because the idea in liquidation is that you sell the assets and you wind up the company. But if the company continues to exist, then it defeats the point of liquidation, because that ideally should have happened during the resolution phase. But that's a technical reading of the law. I personally believe the technical reading in this case merits a little bit more thinking, because we are seeing structures which don't strictly fall within what is legally permissible. So that's one of the concerns which I have. Maybe if there is time, maybe the government could take a look at it.
So while we are on this subject, Suharsh, I was just looking at some of the questions that have come in, and one of the questions is in fact around this topic itself. So maybe we can take it first. It talks about where about this amendment where resolution plan is for sale of one or more assets of the corporate debtor. In case where certain COC members have an exclusive charge on an asset or a business unit, will they not prioritize their personal recovery from the exclusive asset charge to them, leading to more interstate creditor disputes and adversely impacting the overall objective of IBC, which is revival of the corporate debtor? Thank you very much. That's a very good question. In my view, and I can share my view first, and then maybe other panelists can also come in. I think when we are looking at this amendment, and whereby sale of one or more of assets is now sought to be introduced, it still does not take away the fact that the approval of such sale will still have to be by the same COC, and the distribution will also have to be done by the same COC. And it is not that if a particular asset is charged exclusively to one particular creditor, that creditor can sort of carve it out and almost like a liquidation 52 and carry out the sale for that asset by themselves. I think my understanding of this is that if the COC in its commercial wisdom decides that it is beneficial to carve out certain assets or parcels and resolve in that manner, it will still have to be approved by the same requisite sort of 66% and so on and so forth, and the distribution of that will not follow the exclusive charge for one creditor, that basis, but whatever the distribution is decided by the COC for such a asset sale. That's my view. And Suhash, Jayeshbhai, anything you'd like to add?
So, as a sale of a particular asset, you are right, sir. Without approval of 66%, it will not move, right? And it is a common kitty because the resolution is at an enterprise level. So, I don't think that there should be any concern on this particular point.
Sure. So I think, Ashish, probably you have practical experience of this, because I recall in the Jet Airways matter when you were the RP, you were able to achieve this. And I'm not aware of any other precedent where this has been achieved. So again, for those who may not be aware, so when Ashish was the RP in Jet Airways, there was security created in favor of a particular lender over a particular asset of the company. And even during the moratorium, because on the overall picture, that was going to be value enhancing. The fact that if the RP was able to realize that asset, get funds into the company, and use those funds for better utilization, such as buying more assets for the company. So, Ashish has been a pioneer in the sense that he did that even before sort of the regulations and the law permitted. And I think it was in the overall scheme of things, it was a very good outcome. What was achieved in Jet Airways, because the lender to whom the funds were repaid was the lender who had a specific charge on that asset. And more importantly, the other COC members consented to it. So it was done with the consent of COC members, where it was aiding overall value realization. So in principle, I think this is a good amendment. And I think Jet Airways and what the RP was able to achieve gives a very good example of the sort of cases where this can be used.
I think what Suhash did not mention is that it was his advice which helped us all along the way. So, yeah.
Thank you. But I think that really does serve as a very good example of where something like this can be achieved.
Okay. Should we take some more questions here?
Yes.
Requesting members, audience, to please share more questions as you have. But Suhash, you can see the chat box as well, and just let's pick up.
Yeah, there are many questions in the chat box, sir.
Yeah, I just looking at that now.
Yes.
Jayeshbhai, one is a question for you. You can share it maybe on the chat box itself. What are the two cases where group insolvency orders were issued till now, as suggested by you? I think you mentioned about a couple of cases, so maybe you can just answer that. Do you think NCLTs have enough bandwidth and infrastructure to adjudicate applications within the 14-day timeline? Well, I think a lot of timelines and infrastructure is a lot better now than it was maybe 3 years back. I think it's constantly a struggle in India. It's not just about NCLT. I think we are always, more infrastructure we create, the more we need as well. So I think this only time will tell. But I think with more removing certain things, like IRP to become RP, one does not need to go to the courts. The initial default based on which cases are inducted, these would, save time of the adjudicating authority. Stronger penalties on frivolous litigation. These would all go towards freeing up time of the judiciary. So I feel that our NCLTs are doing a great job with the pressure that they are in, with the number of cases that they're faced with. So and this is only going to get better from here. So let's all be hopeful. Whether it is fair to eliminate the innocent public shareholding completely by a successful RA on account of wrongdoing of promoters under IBC, while the company is in profit and equity shares are issued to the banks. Okay. Anyone would like to take this question?
I'll take that question.
Yeah,
and
please.
it's a not a very popular question.
Yeah.
But I mean, I don't think my answer will satisfy the person who's asking the question. But in my view, it is completely fair to eliminate the public shareholder. And the reason I say this so categorically is because the company's net worth has eroded. It is less than zero. The company has a negative net worth. If the company was liquidated, even the secured financial creditors would get a massive haircut. So if you look at the balance sheet of any company, equity always gets paid out after debt is paid in full. If you look at the liquidation waterfall, then also equity gets paid off only after all the lenders are paid in full. So the fact that the company has gone into bankruptcy clearly means that the company is not in profits, it has a negative net worth. Now, whether you are a promoter shareholder or a public shareholder, the fact is that equity value is negative. And when there is negative equity value, it is not possible to give any benefit of a resolution plan to equity shareholders when debt holders, when banks are themselves taking a haircut. This is one of the basic principles of accounting and of finance, not just financial law, but finance the world over. I agree that public shareholders may have been taken for a ride due to malpractices and fraudulent practices by the promoters. But the forum for redressing that is not IBC. The forum for redressing that is securities law, is Companies Act, maybe class action litigation, and so on, but not IBC, in my humble opinion.
So you're right, Suresh. I mean, you'll not be very popular for answering that question in the way you did, but I agree with you on the principles of it, right? The equity of the company is is completely wiped out, and that is an inherent risk of an equity investor vis-a-vis a secured financial creditor, right? I mean, they're very different risk profiles that one is investing in. So yeah, I mean. Yes, more could be done. We know jurisdictions where moment insolvency is sort of initiated. The listed shares of the listed companies are suspended from trading. But in India, we have seen that not only the trading continues, but also there is rampant trading that one sees in these stocks. And there's a lot of, I always admire those investors in terms of real risk takers for an insolvent company to go on trading on those companies. So one takes risks, one will face the risk or reward, I mean the reward from it or otherwise. So moving from there, I think one of the questions here is on liquidation proceedings. Is there any measures to complete the liquidation proceedings within a reasonable time as enacted in law, especially on account of undue delay in appeal proceedings before the Honorable NCLT and NCLAT? So apologies today, given the time frame that we had, we haven't really touched too much upon liquidation, matters or personal guarantor matters. We haven't. I mean, there's so much in this bill we have not been able to talk about, and hopefully, IBSB will set up another workshop or interaction where we can share views on this. I do take note that in the liquidation timelines are sought to be further reduced. From originally, when it started, it was 2 years, brought down to 1 year. Now it is sought to be reduced to 6 months. But there are no real enablers. There are some important changes that have been brought in liquidation as well, on liquidation sections as well. For example, the control of the COC. Now COC is recognized sought to be recognized in the entire liquidation process, and de-recognizing the SCC as it was. Now, this is a fairly massive change, and the consequential changes in the regulations and all these are going to come up in due course. The oversight of COC, along with the power of IBBI to regulate the COC, or at least the code of conduct for the COC, together, I think probably, hopefully, will mean more streamlining in the liquidation process. Moratorium during liquidation, I think that's another very important change that came in, because in a lot of the cases, the liquidator is often seen struggling with trying to protect the assets because there was no moratorium, litigations, ongoing past litigations coming alive. So a lot of time was being spent on those rather than actually selling the assets and liquidating the assets to maximize recovery. So yeah, I think only time will tell how this will pan out. But hoping that this will also improve the liquidation process as well. I think there's another question here. Okay, I think Jayesh has written that. I can't see any more questions in the chat that we are able to see. Sarika, are there any more questions that from the audience that you want to put in here? Sorry, you're on mute, but I guess there isn't. So I think we have another 5 or 10 minutes, and if we are not seeing any new questions coming in this chat box here, maybe we can go back to our chat here, Suharsh, and if we want to pick up any other provisions. I know we have not discussed much about cross-border at all. Would you like to bring in your thoughts on the cross-border framework? We just touched upon it. I know that even now the bill literally just touches upon it. There's not too much in it right now, but any comments from you in that respect?
So I think maybe, Ashish, we'll have to go back to the report which was published by the government for 3-4 years back, the KP Krishnan report on cross-border insolvency. And even then, and I think even today, one of the concerns that I have is that the concept of reciprocity is built in very strongly in our version of the cross-border law, which means that we will be recognizing insolvency processes in other jurisdictions only on a reciprocal basis, only if they recognize insolvency proceedings which are initiated in India. Many major jurisdictions, I would say all, have adopted cross-border law on a non-reciprocal basis. Because I think, again, a principle-based approach needs to be taken as to whether or not we want to permit cross-border insolvency recognition. If there is a jurisdiction, because I think the government's concern is, and the hesitation rather, is that will cross-border insolvency in the overall scheme of things be for the benefit of the economy or to the detriment of the economy? And because the government has that concern, their worry, I believe, is are more assets and debts likely to flow outside India as a result of recognizing cross-border insolvency than flow into India as a result of adopting cross-border insolvency. Now, my thoughts are that we cannot be instrumentalist in this approach. We need to be principle-based because we don't know which company in the future can face such proceedings. It could well be the case that there is a company which has center of main interest in another jurisdiction, but all its assets, income, employees are based in India. And that especially happens for tech companies because you'll find tech companies are often registered in Ireland, in Singapore, and some of the other offshore jurisdictions. But the operations are held in India. The income, revenue, employees, everybody is in India. So in those cases, if there's a bankruptcy proceeding overseas and we don't recognize it because we don't have reciprocity, it is to our detriment. At the same time, there may be companies where the registered office is in India, but the operations primarily are based in another jurisdiction. And that could be some of our main IT companies. So over there, it may not be, in the overall scheme of things, we may be prioritizing rights of other creditors. Short point I'm making is we cannot pick and choose. I think in the cross-border law, as and when we adopt it through delegated legislation, we should take a principle-based approach on reciprocity. That's one concern I have on cross-border.
I agree. Jayesh bhai, any other amendments that have been brought in here? Anything that you think? Yeah.
So there's a new question. Like
Okay.
someone has asked, there are cases where post-issuance of RFRP, the COC is not in receipt of feasible and viable resolution plan, but there may be a Section 12A proposal which could have been better than existing resolution plans received. Is the restriction on moving Section 12A application post issuance of RFRP detrimental to the interest of the lenders who are otherwise forced to push the company to liquidation?
I think if I can answer this, then 90% approval of the COC, the 12A can be approved even after this process. So 90% COC, if they are agreeing, then 12A can proceed. This is my view. Only one or two more points, because most of us are chartered accountants here, and audience is also chartered accountants. We need to, stress on use of technology, and there is a provision for tech platform in the amendment bill. Then there has to be capacity building for all of us to take larger assignments. This is what, because if you are going to deal with CIRP matters, then capacity will definitely be most important. Alone RP cannot handle this whole process. This is my view.
Jay sir, you have put in your cases in the chat box, but rather if you can speak about it, that would be great, as members are not able to see this chat box.
You're on mute.
I discussed about Darshan Developers Private Limited, which I have already covered, where 11 companies consolidation happened, and the order has been passed by NCLT on 27th of June 2025. And there are other two matters where the process is on and where consolidation process is going on, and they will be consolidated by Honorable NCLT, and CIRP will proceed further. So this is what is the status. But this new provisions will definitely help in such type of cases where it takes a lot of time otherwise, because there were no such provision. With this new provision, it will help to consolidate. Particularly, it will be beneficial for real estate projects where there can be different entities owning, having different rights over a particular project, and there is one single project, but rights are there in different companies. So definitely, it will help in this new amendment. Reforms will help.
Sir, one more question. Any amendment for smooth implementation of plan? Sir, all big IPs have joined this webinar, so they are asking this kind of questions. So this question.
So implementation of the plan is always a challenge, according to me, because in real estate, in particularly, some SRA authorities have revoked the license even after the approval of the plan, because these are all decisions taken by local pressures and local involvement of a lot of people. And sometimes even after the passing of the resolution plan, the projects are not getting implemented. This will be a big challenge. And how do we smoothly implement a plan is it depends on the capacity of a resolution applicant. And now there are good changes also which are being proposed, whereby implementation committee implementation, it will be formalized. So all this is, will be in the right direction. This is my view.
I think, a couple of notable amendments, albeit, looks to be very small, but I think that would really have a good impact on the resolution process or the liquidation process, as the case may be. Maybe we can just discuss about that. I was just flipping through my notes, and I had made a note of the slight change that has been brought about in the role of the RP when it comes to verification of claims. So during CIRP, what was, again, based on the earlier Supreme Court orders, it was fairly common to see that RPs were more about verifying and collating the claims rather than actually making a determination of the claims. But what is now proposed is a more sort of adjudicatory sort of responsibility when it comes to the claims process or claim verification. This, coupled with the fact that now the liquidator will not be required to, invite claims again. I think if you look at both these together, this is going to basically expedite the whole process in case the companies do slip into liquidation, and also the numerous litigations on the claim side, because RP, based on the jurisprudence, was basically doing more of a verification, broad arithmetical calculation, he or she was not taking a judgmental call. But now RP will be required to also make a determination on the claims. I think this is an important change. Also, if you see, the expanding the definition of the cooperating parties in terms of for the resolution process, bringing into the ambit for the service providers in the process, ex-employees. All this is basically trying to plug some of the inefficiencies that had crept in, and also hopefully reduce litigations, those 19 applications that were being filed. So it is definitely a very, and there are many more. There are many more, look back provisions and so many changes that have been brought in. We can go on talking about this, but I think in the interest of time, I'll pause here. And
Sir, one last question. I want to liquidate my proprietor business. What are the implications of insolvency code? What are the resolution plans for it? I think he is very new.
So
he does not have.
I was going to come to it. Partnership and proprietary ships have not been covered so far, and God willing, and they should be covered at one stage. But that reform will take time, I think. Other thing on the verification of the claim, there is a valuation of the claim concept which has been introduced. Now, this is particularly important for a real estate project when sometimes certain areas are given to certain co-developer or a joint venture or a landowner. So that valuation of the claim, it becomes very critical according to me. So that is also a good amendment. The other amendment, which is regarding PUFE transaction, there are many other things, but PUFE transactions can be pursued and has to be pursued even by liquidator. So that all really adds value. These all amendments are good amendments according to me.
Suresh, any closing comments or remarks?
No, I think given the time constraint we have, we've been able to cover quite a bit of ground. And I don't have any closing comments other than expressing my gratitude for being invited to this forum, to be able to speak before an audience which is so well informed, with a panel which is so distinguished. Sarikaji, thank you. Thank you very much.
So with this, I think we can now wind up this session. Or any closing comments by Jayesh sir and Ashish sir?
No, these reforms are very good for us, and as our president and also Gyan Mishra ji said, for Viksit Bharat, all these reforms are necessary. And all of us, I think, here agree that all these reforms will be beneficial at the end of the day for development of the economy.
Ashish sir?
Nothing further to add. It just this will probably breathe in some life again into a law which seemed to have been, people are putting it into the drawers, saying that yet again, one of those laws which has, not given the desired results. But I think this will breathe in some life back into the law. And so, yeah, looking forward to the next phase of IBC 2.0, as it is called.
So with this, on behalf of Insolvency and Valuation Standards Board, I thank each one of you. Like Ashish sir, thank you so much for sparing your valuable time. Jayesh sir and Suhar Sinha also, thank you so much. Then Gyan Mishra ji in his absentia, Rajesh Sharma sir, President ICI, who was part of this inaugural session, Jitesh John sir, who had to leave because of a meeting in ministry. And thank you each one of you for continuously joining with us. Thank you each and everyone. Thank you everyone.
Thank you.
Thank you.
Thank you. Haan ji.